we're here with Professor Merritt Fox from Columbia Law School. It's a pleasure to have you here as a visiting professor of the Global Law Program. And we're always interested to know more about the U.S. Securities Regulation because it's always an interesting source to better understand how to improve or the other strategies to regulate capital market. So I'll ask you, you're here as a visiting professor teaching the course Securities Regulation, a Law and Economics Approach. Could you tell us a little bit about this course, the issues, the perspectives? Tell us about the course a little bit.
Sure, and I should say it's a real pleasure for me to be here at FGV. It's my second stint as a visiting professor here, and I was delighted when I was invited back. So about the course, over the last several decades, financial economics has become a very important branch of economics in general, and it has a lot to say about a variety of kinds of issues that securities regulation addresses. And particularly in the United States, the learning that comes from financial economics has begun to make its way into the minds of legal decision makers, into the minds of judges, the SEC, which is our CBM, into even the minds of congressmen and amendments to legislation. And it forms a way of trying to understand, first of all, what are the consequences of legal rules. Mm-hmm. So the theme of the course is to use financial economics principles to understand the benefits and the costs, basically, of different securities law arrangements. In the course, we look at four main topics. One is disclosure regulation. Both the United States and Brazil have rules, in each case somewhat different rules, that require publicly traded companies or companies that are offering their stock publicly to disclose certain information about themselves. So the first topic we look at is sort of what is the function of that? What benefits come from that? And do you need government regulation, or could we rely on the market to provide incentives to companies to provide information? Then the second topic we look at is insider trading by the insiders of corporations, where they know things that the public doesn't. If it's positive, they buy stock. If it's negative, they sell stock. Then we are looking at the use of private lawsuits for damages against corporations that make misstatements, that tell lies, basically. And then finally, we'll spend a little bit of time talking about how economics could have some interesting things to say about which countries' rules should apply to which issuers when. In a world where we've got 40,000 publicly traded companies, many of them, there's a global market for their shares, that raises very interesting questions as to potentially many different countries' securities regimes could regulate them, but that would be really very paralyzing. So which regime or small number of regimes should?
Okay, great. And yesterday we had our first external workshop, and we discussed your paper, Informed Trading and its Regulation. What is the main idea of this paper?
Well, I think I just mentioned insider trading, but insider trading is really a member of what we might call a larger phenomenon, which my co-authors and I have labeled informed trading. And informed trading is anybody who's trading on information that gives them, whatever the kind of information, a better prediction of the future of a company than the prediction that's reflected in the current stock price. And if you have a better prediction, on average, you're going to make money based on that prediction. If you think the company's going to do better than the price suggests, you buy, and when that understanding becomes more public, the stock price will go up, and you'll make money, and the reverse if you know negative things. So there are lots of kinds of informed traders, people who just go out and look at the world and gather up bits and pieces of little bits and pieces of information and put it together with good economic understanding and analysis and come up with a better prediction. Those are informed traders. They have an advantage over other people. Another group are people who hear public announcements and run out and buy or sell based on those very, very quickly before that information is fully reflected in price yet. Another is the classic insider trader I was just talking about, and the final one is somebody who works for or hears from somebody who works for some outside institution that has information that's relevant for the future of a company. For example, maybe a planned takeover or a big contract or whatever, or even a government ministry that will be making some decision, like a drug approval or something like that. So those are all examples of informed trading. And what the main theme of the paper is, all informed trading improves the accuracy of stock prices. And that's a good thing. More accurate stock prices make the economy work better. But all informed trade also decreases liquidity in the market, makes it more expensive for people to trade in the market. And so there's a trade-off. And what we try to do is figure out what kinds of informed trade are on balance socially beneficial, where the price accuracy benefits are more positive than the liquidity damage harm is negative, and which ones is the reverse. And on the whole, we think fundamental value trading is good, announcement trading is bad, insider trading is bad, trading based on the information inside a third party is okay if it's with the consent of the third party, but bad if it's not.
Okay. And nowadays we're thinking how to improve the enforcement system, mainly to investor protection, compensation of their loss when we have the fraud on the market. And comparing the US system and the Brazilian in the Petrobras case, we can, it revealed that they are very different systems. What's your opinion about the US private litigation system, and can we learn something about the private litigation? How to improve it, or do you have some idea?
Yeah, I think it's a very interesting subject. Now, is the US system permits shareholders who have, let's say, purchased shares at a time when a company has made a misstatement that boosts the price of the share. If they purchase shares when the price has been inflated and they still are holding those shares after the truth comes out, and so the price deflates, and they suffer a loss, allows them to sue the company even if the company hasn't itself done any trading in the securities, and the officers and directors haven't done any trading in the securities. Does the system work well? I think it depends. In the US, I think it would depend on who you ask. It's a very controversial subject, with some people who think this is a very good thing and other people who think it would be great if we could get rid of this right. My own feeling, and I think this represents a significant majority view among economically informed commentators, is that the compensation justifications for these lawsuits are not very good, because it's being paid by the company, and it really means ultimately it's being paid by the shareholders of the company. But where there's more debate is about the deterrence function, because obviously companies don't like to get sued, and so if they are afraid of getting sued, if they make misstatements, they're less likely to make those misstatements. Some people, I think myself included, feel that the system is worthwhile because of that deterrence function. But there's a respectable argument that it's not, because it's a very expensive system. Billions and billions of dollars are spent on legal fees by both sides in these lawsuits. The time and energy of the top business executives of companies gets tied up in these suits. It's not a trivial matter at all for a CEO to have to spend a couple of days being deposed by lawyers and time at a trial and so on. So the question in some senses is, do we get enough deterrence of bad behavior to justify these costs?
Okay, now I have a question about how to develop a capital market for small and medium companies. And we're trying to do this in Brazil. It's a big challenge. Do you have anything do you think we should consider any specific aspect to try to develop the small and medium offers, how to do it, and where can we start?
Well, it's a wonderful question. It's an incredibly difficult question. I should start by saying it's an issue in the United States too, even though clearly the U.S. market is working better in that regard than the Brazilian markets. I think the data that I have seen suggests that the sort of median size IPO in the United States is about 1/10 the size of in Brazil. In other words, only quite big companies making quite big offerings are going to the public market in Brazil over the last decade or so. And that it's considerably smaller companies with smaller offerings can be successful in the United States. I don't think there's any magic solutions. I do think that the stronger the corporate governance laws, most Brazilian corporations have control shareholders, the stronger the laws are to restrain those control shareholders from getting more than their share of the wealth that's created by the company. I think the better that works, that will help create a public market, because otherwise there's always a great deal of uncertainty as to if you buy in an IPO, there's a great deal of uncertainty as to what the control shareholders will do to you. And a rigorous disclosure system also helps people separate the good offers from the bad offers, because if they can't separate them, they're going to kind of assume they're somewhere in between, and then the really good companies say, well, then I have to be penalized because people think I'm not really a good offer, so I'll try and raise my money some other way. And then the quality of issuers goes down, and the same thing can play over and over again, and you can end up with a very small market.
Okay. And how about your research agenda? What's in your mind for the next years? Could you tell us?
Well, I'm working right now on a book with the co-authors on the Informed Trading paper on basically the law and economics of capital market, equity market regulation. So this isn't focusing so much on the topics of the course this week here at FGV, but more on what we call market structure issues. So issues like whether high-frequency traders should be able to have special access and see what's going on in the markets ahead of other people. We do have a chapter on informed trading. We have a chapter on manipulation. And we have a chapter on short selling. We have a chapter on fiduciary duties of brokers. So it's dealing with those kinds of questions, so-called maker-taker fees and so on. So that's where my big effort's going to be the next year.
Well, when it's ready, please tell us, because it seems very interesting. Well, thank you very much for being here and for talking with us at this time. Thank you very much.
Well, it's my pleasure.
Okay.